Maybe we give it a couple more minutes to see if some more people filter in, and then we can get started.
So are you guys in class, like normal class, or is everything is Zoom? What's the COVID situation?
It's 100% online right now. Yeah. And we're trying to sort out what's going to happen next semester. How are things for you? Are you teaching at American?
Well, I don't know yet, because that's usually in the spring semester, and they haven't finished their plans for the spring semester as yet. They've had 25% cuts in AUB. So I don't know what's going to happen with, what they're going to be offering, what they're not going to be offering. So it's the situation here is terrible on absolutely every level. There's nothing that's going right at the moment in Lebanon, absolutely nothing. And so, I mean, including the FPL, mind you, which is cutting 40% as well. So it's, things are changing rapidly, and not necessarily in a good. I mean, this country is just unbelievable. From the start of the revolution on the 17th of October rather, last year, like now it's a year. It's a complete collapse of everything. It doesn't. It's incredible, and then of course culminating with the blast in August.
Yeah, that was so shocking.
Which was just out of this world.
Yeah.
It's crazy. It's never ending.
How's the recovery from the blast? Is there any reconstruction going on, or?
There is, basically, to, particularly to get people back into their homes before the winter, because I don't know, nearly 200,000 people were left without a roof over their head. But the city is unrecognizable. It's devastated. It's absolutely devastated. It's horrible. Every time I go down there, I'm, shocked. You would think you get used to it, but you just don't.
Yeah.
It's unbelievable. It's unbelievable. It's indescribable, really. Nothing, mind you, we've seen Sarajevo, we've seen Vukovar, we've seen these things. It's not like, it's just, it's different.
Yeah. I'm so sorry to hear that. I mean, Beirut's such a beautiful, beautiful city, and I can't imagine, what it must look like. And it's down by the water, right? It's right on the
it's basically the entire center of the city. All the places that, it's the center of the city. The center of the city has been completely gutted, effectively.
Wow.
It's and in 2 seconds as well. It's not like,
Right. Yeah.
So we'll see.
Yeah. Well, should we get started, Nora?
Okay. Yes, I think that sounds good. Thank you. Okay. Hi, everyone. Thank you so much for joining us. My name is Nora Ghanem. I'm the Academic Events Chair for USC Gould's Middle Eastern and North African Law Students Association. We're so excited to welcome you guys to our first event this semester. And I want to thank the International Human Rights Clinic and the International Law and Relations Organization for co-sponsoring the event with us. And with that, I'll pass the mic along to Iger, the director of ILRO, to say a few words.
I'm the director of human rights of the ILRO, but thank you. Speaking on behalf of ILRO, we are the International Law and Relations Organization. And just as a quick heads up to any students who have logged on, we are hoping to plan a networking event with alumni who work internationally. So keep an eye out on your emails for that. I also wanted to echo Nora's words and thanking Professor Gary for setting this event up. And thank you, Ms. Kavran, for joining us. And we are looking forward to hearing from both of you today. Thank you.
And with that, I will introduce our moderator, Professor Hannah Gary, who is a professor of law at USC Gould and the founder of USC's International Human Rights Clinic. Her areas of teaching and research include international criminal law, international human rights law, international humanitarian law, and international refugee law. She has vast experience in international criminal law and tribunals, and she previously served as counsel amici of the former United Nations Special Rapporteurs in the Afghanistan investigation appeals hearing at the International Criminal Court. She served as senior legal advisor to the Supreme Court Chamber and the Extraordinary Chambers of the Courts of Cambodia, and as a visiting professor in the presidency of the International Criminal Court. So without further ado, I will pass things on to Professor Gary to introduce our speaker. Thank you.
Thank you so much, Nora, and good afternoon, everyone. It's great to welcome you all to this event and this panel discussion on the Special Tribunal for Lebanon and its historic trial judgment in the Ayash et al. Case involving the 2005 assassination of former Prime Minister Rafiq Hariri of Lebanon. So thank you so much for joining us. And I apologize in advance, my dog is going a little bit ballistic right now. So if you hear him in the background, please try to ignore. And so I want to thank you all for being here. I also want to thank our guest speaker, Ms. Olga Kavran. And is it okay if I just call you Lola throughout?
Of course.
Because I know her as Lola, an old friend, and she is, I'm going to introduce her more fully in a minute, but she is head of the Outreach and Legacy section of the Special Tribunal for Lebanon. And we really appreciate you taking time to speak with us today and share your expertise, particularly given that you're doing so from Beirut, where it's definitely a different time than it is for us here in California or on the East Coast of the United States. So as you heard, I'm Hannah Gary, and I am a clinical professor here at University of Southern California Gould School of Law and director of the International Human Rights Clinic. And in the clinic, we engage law students in legal representation and advocacy. And one of the areas that we have been working in since our launch in 2011 is in international criminal law, partnering with a number of international and hybrid tribunals, assisting the judges and the legal staff there on cases that involve prosecution of high-level perpetrators for some of the most serious human rights abuses that we say rise to the level of international crimes. So here I'm talking about grave abuses such as war crimes and crimes against humanity and genocide, and also aggression. Now, since 2012, the clinic has had the honor of coming alongside the Special Tribunal for Lebanon in particular, and working with its appeals chamber and Office of the President. And as you're going to hear more today, the Special Tribunal for Lebanon is a hybrid tribunal that has both Lebanese and international staff and applies Lebanese law and some international law as well. So it's a real mix. But it's based in The Hague, the Netherlands, and has been doing historic work in that it is prosecuting those alleged responsible for a terrible terrorist attack that took place in 2005, as I mentioned before, where the prime minister was killed along with over 20 others and hundreds were injured, and there was massive destruction in the heart of Beirut. So the STL is the first tribunal of its kind, and the first for the Middle East, and the first to issue a decision early in its lifespan regarding terrorism as possibly being an international crime in and of itself under customary international law. This fall, I just want to call out two student attorneys in the clinic who are working with the Special Tribunal for Lebanon, Nya Do and Igarim Sadabayeva, I'm sorry. And they have had the particular honor of working with the appeals chamber on the upcoming appeals from this trial judgment that was rendered this past August in the Ayash case. So now I'm going to introduce Lola a little bit more in detail, but I do want to say, just join the words of thanks and appreciation for those of you who organized today's event. I want to especially thank the Middle Eastern and North Africa Law Association, Nina and Nora Ghanem, particularly for all of her work in the logistics and advertising, and also to thank the International Law and Relations Organization, Igarim and others for coming alongside to help or advertise the event. So now Lola, so as you heard, she's head of Outreach and Legacy, and she has been at the tribunal since July of 2010. So for most of the life of the tribunal, right? It was established in 2007, if I'm remembering correctly.
Yeah, 2007, but it started work in 2009. So
Wow. So you've been there literally from the beginning. But prior to that, so Lola and I share the experience of having worked at the International Criminal Tribunal for the former Yugoslavia. And she was there from 1997 to 2000 as a translator, and then she was outreach deputy coordinator from 2000 to 2006 and spokesperson for the prosecutor from 2006 to 2010. So an extensive background, obviously, in international criminal law. Before joining the ICTY, Lola worked for 4 years in advertising and public relations and has received a number of awards on that front. So it's no surprise you have this role at the Special Tribunal for Lebanon. In terms of her background, she has an LLM in public international law with a specialization in international crim from Leiden. And just for all of you who are interested potentially in doing further studies after your JD, Leiden University in the Netherlands is one of the top for studying international criminal law, and it's located right there near the Special Tribunal for Lebanon and a number of other international courts and tribunals. It's you know, the Leiden itself is close to The Hague, the Netherlands, which is the city of international peace and justice, and kind of the mecca for those who are interested in public international law. So Lola has published and taught on the topic of international criminal courts and tribunals and criminal proceedings. And she's also been a lecturer at American University in Beirut. So after we hear from Lola today, I'm going to moderate a Q&A. And while she's speaking, feel free to go ahead and put your questions in the chat. You're going to be muted throughout her presentation, obviously, but when we go into the Q&A, after I read out the questions from the chat, Lola invites direct, questions as well. So just please go ahead and put your hand up. You can literally do that or just use the Zoom function, and I'll try to keep on track of calling you out so you can present your questions. And now I think that's it. So thank you again, Lola, and I invite you to proceed. Thank you.
Thank you very much, and thank you so much for this invitation and for the opportunity to share some information about the STL and its judgment. So what I will do is I will use a PowerPoint presentation. So perhaps you can follow along a little bit better. And we will start with this. So what started all of this many years ago was in fact the explosion, as Hannah mentioned, on the 14th of February 2005, which killed the former Lebanese Prime Minister Rafiq Hariri and 21 other people. And it also injured 226 individuals. Before the most recent blast in Beirut, this was the single biggest explosion that happened in the city. And the judges found that it was the equivalent of between 2.5 and 3,000 kilograms of TNT. The venue of the explosion was also carefully chosen. It was in between two very tall buildings to maximize the impact of the explosion. But luckily, those buildings did not at the time have too many people in them, hence the relatively moderate number of those who perished and who were injured. I mean, relatively speaking, given the size of the blast. Later that afternoon, on the 14th of February, the Al Jazeera news network in Beirut received calls claiming responsibility for the attack and a videotape that it later broadcast because it was threatened to do so. In the video, a young Palestinian man, Mr. Ahmad Abu Adas, claimed on behalf of a fundamentalist group, which apparently does not exist, which he called Victory and Jihad in Greater Syria, to have executed a resounding martyrdom operation, as it was referred to, against Mr. Hariri. The judges, of course, in the judgment later did rule also that this was a terrorist attack committed by means liable to create public danger and intended to cause a state of terror. The judges said that the attack was intended to resonate throughout Lebanon and in the region, and its intended effects were not just confined to Mr. Hariri's supporters, but that it was the evidence and the political background demonstrate that it was designed to destabilize Lebanon generally. And indeed, it did. What you saw in the immediate aftermath of the explosion is that the United Nations sent a fact-finding mission to Beirut, which found that the local investigation was lacking on every level, and recommended the formation of an international investigative body. Meanwhile, in the streets of Beirut, on March 8, in response to the international outcry and condemnation of Syria, because Syria had been the power on the ground since the end of the Lebanese civil war. So there was widespread condemnation of Syria, in response to which forces within Lebanon that were supportive of Syria demonstrated on the 8th of March. And those are the photos you see on the left-hand side of the slide. The 1559 number you see refers to Resolution 1559, which had been passed by the Security Council in October 2004, September, I believe, 2004, demanding that Syria withdraws from Lebanon, which hadn't happened up until that point. In response to the March 8 demonstrations, there were on the 14th of March, began what was later referred to as the Cedar Revolution. And this revolution ultimately brought an end to Syria's presence in Lebanon after 29 years. So Syria began shortly after these demonstrations. In their aftermath, Syria began withdrawing its troops, and the final withdrawal was completed at the end of April 2005. In the meantime, the United Nations established an international independent investigation commission by Security Council Resolution 1595 in April 2005. And its purpose was to gather evidence and to assist the Lebanese authorities in their investigation of the attack of 14 February. The mandate was later expanded to include the investigation of other assassinations that took place before and after the Hariri attack. It's important to keep in mind that the UNIIC, as it's often referred to, was a separate international organization to that of the Special Tribunal for Lebanon. The UNIIC was a UN body established by and financed by the UN, and it was mandated to assist the Lebanese authorities in their investigation, whereas the Special Tribunal for Lebanon, as Hannah pointed out, is a hybrid international tribunal that opened its doors in 2009, as we will see shortly. Just to give you a bit of a background as to what happened in the next couple of years, because it's important, and it's important to see the dynamic as well. So between March and December 2005, there were 14 other attacks. And my friends here in Beirut described the period as literally feeling that every week someone else was getting blown up. So it was, in fact, a continued state of terror that people who lived here at the time speak about. On the 13th of December 2005, the Lebanese government at the time requested the United Nations to establish a tribunal of an international character to try those responsible for the attack of 14 February. In response to this request, the Security Council adopted Resolution 1644, in which it requested the Secretary General to negotiate an agreement with the Lebanese government to establish such an institution. Things progressed rather quickly in terms of the way that things can sometimes be slow at the UN. And and after negotiations, the UN and the Lebanese government signed an agreement on the Special Tribunal for Lebanon, which was sent to the Lebanese parliament for ratification at the beginning of 2007. However, the Speaker of the Lebanese parliament, then and now still, was opposed to the establishment of the STL. and therefore refused to convene the parliament to hold a vote on ratification because the majority of the MPs were in fact in favor of establishing the tribunal. So on the 14th of May, the Lebanese Prime Minister informed the Secretary General that 70 of the 128 members of Parliament of Lebanon had expressed their support for the tribunal and asked him to request from the Security Council that the Security Council in fact establishes the tribunal due to the political impasse in Lebanon. And this is in fact what happened. On the 30th of May 2007, the UN Security Council issued Resolution 1757 by which it established the Special Tribunal for Lebanon. The tribunal began its work on the 1st of March 2009. And as Hannah said, it's based in Leidschendam, right next to The Hague in the Netherlands, and has an office, of which I'm part, here in Beirut in Lebanon. The Special Tribunal for Lebanon has jurisdiction over the attack of 14 February 2005, but also over the attacks between 1 October 2004 and 12 December 2005, if connected to the Hariri attack and are of a similar nature and gravity. This connection includes, but is not limited to, a combination of the following elements: criminal intent or motive, the purpose behind the attacks, the nature of the victims targeted, the pattern of the attacks, and the perpetrators. The tribunal could also have jurisdiction over crimes of similar nature and gravity if they're connected to the Hariri attack after 12 December 2005, but only if so decided by the parties and with the consent of the Security Council. Now let us move on to, so these are the basics about the establishment of the STL. Of course, if you have any questions about that, I'm happy to take them after the presentation. But now I'll move on to the case, the main case, which is Prosecutor versus Ayash et al. In that case, there were initially 5 accused. Well, that's anyway, the shortened version. There were initially 4, then the 5th one was added. But the trial proceeded with 5 accused: Mr. Ayash, Merai, Onesi, Sabra, and Badreddin. Mr. Badreddin is presumed dead, as he was allegedly killed in Syria in 2016, and therefore he was no longer from that point on formally accused. But the judges have ruled that his death is to be taken as, or rather they concluded the case without prejudice, meaning that if it should ever come to light that he might actually be alive, that the case could resume. But for all practical purposes, he is presumed to be deceased. They were charged with conspiracy aimed at committing a terrorist act by means of an explosive device, intentional homicide of Rafiq Hariri with premeditation by using explosive materials, intentional homicide of 21 other persons with premeditation by using explosive materials, and the attempted intentional homicide of 226 persons with premeditation by using explosive materials. Those were the charges against Mr. Ayash. The remainder of the accused were charged with conspiracy aimed at committing a terrorist act and being accomplices to the remainder of the charges. I should point out that the tribunal has jurisdiction, or rather that the crime of terrorism is defined as it is in Lebanese law. So the tribunal applies Lebanese substantive law, but in terms of its procedural law, it is very much similar to all the other international criminal courts and tribunals, and not necessarily to the Lebanese legal system. That's in terms of the procedure. But in terms of substantive law, it applies Lebanese law and the Lebanese definition of terrorism. Another point to add to that is, as Hannah pointed out, the judges in 2011 did issue, the appeals chamber judges did issue a very interesting, although controversial decision, ruling that terrorism is in fact defined as a discrete crime under international law. Now, there was a lot of disagreement among academics of that view, but it's nevertheless a very interesting and very important decision that I would invite any of you who are particularly interested in the issue of terrorism to actually read, to look at the judge's reasoning as to why they found that this was in fact the case, and then also to read those who oppose the view to make up your own minds. But it's a very interesting decision, unanimously delivered by the judges of the appeals chamber of the Special Tribunal for Lebanon. Moving on to some statistics. So the case began on the 16th of January 2014, and closed in September 2018. The statistics of the case are that there were 297 witnesses. There were 3,135 exhibits, totaling 171,000 pages. The judges sat for 415 days in trial. There were a total of 1,516 decisions by the judges at different pretrial, trial, and appeal level, and 74 victims originally participated in the proceedings, because the STL provides for the participation of victims who are represented through their counsel in the trial. Another thing that I should mention that sets the STL apart from other courts and tribunals of the same nature is that it has a defense office as a separate organ. I don't know how familiar you are with the structure of international tribunals, but they usually have registry, chambers, and office of the prosecutor. And in the case of the STL, in addition to those three organs, there is the defense office. Each of these organs in all of the tribunals always has roles which are different, and in addition to those that they might have in a national system. And that's because there is no executive branch, there is no legislative branch at the international level. You only have the judiciary. So the judiciary has to take on board and perform a lot of different tasks, such as diplomatic relations, such as running its own security, even its own detention center where such a center exists, and so forth. So there's many roles for the courts, international courts, that local courts would not have, because they would benefit from the state structures to support their function. One of these roles, of course, is also what we do, which is trying to explain the work of the tribunal to particularly those most impacted by it, but also to anyone else who is interested in the topic. In terms of the evidence that was presented in the case by the prosecution, it included forensic evidence, it included witness testimony, it included documentary evidence such as banking info, medical records, insurance documents, and so forth. It included expert testimony and analysis as well. But the main evidence that was used by the judges, by the prosecution, is telecommunications evidence. And this is basically data and information about mobile phones and networks. Now, before I move on, one thing that I would like to stress and to get you to keep in mind, because it is very important, is that we're talking about 2004 and 2005. We're not talking about smartphones. We're talking about your regular old, usually Nokia, sometimes other phones, but we're not talking about smartphones. So the data that was being collected is about the location of the phone, about the duration, the date, the duration of the phone call, or whether it was a text message. There was no, again, WhatsApp at the time. It was text messages and phone calls mostly. And this is the data that is collected by the providers in order to issue a bill at the end of the month. So this data is seen as objective for the simple reason that it's a business issue for these providers. So they collect this data from any one of us who uses a phone in order to be able to bill us at the end of the month. The telecommunication evidence consisted of call data records, which I just described, but also those things which could attribute a phone to a particular user. So those would be subscriber records, testimony, cell site information, location, IMEIs, which are the individual numbers that are associated with a handset as opposed to a SIM card. So those remain the same even if you change SIM cards, but they register, the IMEI is registered to the network every time the phone connects with the network. In some cases, there was SMS content, geographic profiling, contact profiling. Now, geographic profiling is, for example, where a phone seems to be at particular times of day. So, for example, if my phone is with me at a particular location every single night throughout the night, a sensible conclusion is that that location is probably my home. And at the same time, if that same phone is in another location, but usually between 9 and 5 or other usual working hours, then it's a sensible conclusion that that location is where I work, even absent other information. So this is the kind of stuff that investigators would have been looking at. Contact profiles is, of course, who the phone is in contact with, obviously, and the frequency with which it contacts people can be used, again, to deduce information, or rather conclusions. Collocation is another thing that was used in this sense. And that is, for example, if you have two telephones and they always happen to be together, again, it's a safe assumption that they belong to the same person. This is just by way of illustration of what kind of things the investigators were looking at. Of course, there's also dislocation, which is the impossibility based on evidence that a single person is using multiple phones. Again, if phones are constantly in two different locations, that can be an easy conclusion to draw. And so on. Why was this all important? Because the subscriber records back then, again, we're talking about 2004, 2005, were not at all always reliable. People were not always back then obliged to provide valid IDs, or even to buy SIM cards under their own names. It was also handled very differently then than it is now, even in Lebanon, but also everywhere else in the world. So the situation was quite different. So the subscriber records were not necessarily always going to be reliable. And the phones would have to be attributed to people through other methods. So what does a call data record look like? It looks like that. And I think you can see it on your screen. It's not easily intelligible. It is basically metadata of phone calls. So what the investigators did is they analyzed literally millions of phone calls and arranged them into something that is much more intelligible, or at least arranged the relevant ones into something more intelligible, which they referred to as the call sequence tables. And these call sequence tables organize the info for accessibility, presentation, and analysis, but they basically contain that info. So it's the date of a call or an SMS, the time, the outgoing and incoming number, whether it was a voice call or an SMS message, the identifying number of the actual handset, the cell tower, which the telephone triggered when the phone call began, or the message was sent, and then the cell tower which it triggered when it concluded. Now, I don't know how familiar you are with the way that mobile telephony actually works, but there are, all around us, there are many cell towers that are placed by the mobile phone providers in different locations, and they pick up your phone call as you move between them. So sometimes when you're moving through the city, you might find that your connection drops. That's because your phone has fallen in between cell towers, so to speak. In some business environments, you will find people choosing one provider over another precisely because one provider might have more cell towers and therefore might provide better coverage even in remote areas than another. So it's this information that we're talking about when we speak about cell towers. How might it look when the investigators looked at cell sites to analyze and track a phone's movement over time, and then to establish things like, for example, co-location? So basically what you're looking at is different areas covered by different cell towers, right? So if you have two phones or a number of phones that are all together triggering the same cell tower in the blue area that you see on your screen, that may be an entirely random occurrence. If a certain number of phones then moves on to the green area and they're still together, it may be possibly a group of people on the same bus, but not necessarily together. As you move through the yellow and then the orange and then the red and into the darker red areas, the phones that still remain together are in all likelihood somehow connected. Either it's people who are together or it's one person with several handsets. So these are the kinds of deductions that were being made. The prosecution alleged, and later as we will see, the judges agreed with that, there were 5 interconnected mobile telephone networks or groups that were involved in the planning, preparing, and executing the attack of the 14th of February. For ease of reference, they color-coded them, okay? So there was the red, the blue, the green, the yellow, and the purple networks. The trial chamber in their judgment found that the green, red, blue, and yellow networks were interconnected and coordinated with each other and operated as covert networks at the relevant times. The users of these networks took extreme care to limit their traceability. So, for example, all the red phones were bought at the same time by one individual, not in Beirut, but in a city north of Beirut, in Tripoli, because that was obviously part of the ploy to for the false claim of responsibility, because the person who was allegedly, who had, according to the false claim, would have killed Rafik Hariri was meant to be an extremist who might have come from that particular or have had connections in that region of Lebanon. So nothing was left to chance. A 5th group of mobiles, the purple group, was allegedly used to communicate with each other and outside the group to coordinate the false claim of responsibility. Now, the trial chamber established that Mr. Hariri was under surveillance from October 2020th of October 2004 to Monday, the 14th of February 2005, with the surveillance in the latter period connected to his possible assassination. So the judges could not determine that the surveillance was always with the purpose of assassinating him. It might have also been simply for tagging his movements and watching his movements, but that the later in that period, an intention definitely formed to commit the assassination. And they found that there was unequivocal pattern in the mobile networks shadowing Mr. Hariri. However, the judges also found that that does not mean that every user of every network mobile knew about the mission to assassinate him, either in detail or at all. That's also important. However, the sheer numbers are quite remarkable, because there were anywhere from around 20 to possibly even over 50, 60 individuals involved in this activity. Again, not necessarily all of them knew what the purpose or what they were part of, but it's quite a sizable operation. The defense, of course, presented its case, mostly during during the presentation of the prosecution evidence. There was not much of a separate defense case at the end. In fact, only one accused chose to present additional evidence. But sorry, I'm just talking on my computer, which is complaining. Okay. But the issues that the defense raised in their submissions during trial and in the final briefs is that, again, this is just examples of arguments, that all evidence is circumstantial, that the political context was presented in a biased way, that the server coverage is not particularly accurate, that the telecoms evidence itself is unreliable, that motive should have been explicitly pleaded, that there was no proof of agreement between the perpetrators, and also that there are other possible suspects. Again, I'm not doing justice to all of the prosecution or defense arguments, just trying to give you an overview. But all of the documents related to the case, including all of the briefs, are available online on the STL website. Now, some additional highlights from the judgments. The judgment itself is 2,641 pages. The judges also issued something that I haven't personally seen at any other tribunal, and that is an authoritative summary of 149 pages to make it more user-friendly, as it were, to make it easier for people to actually read, because they were fully aware of the fact that it probably takes a lot of enthusiasm to read 2,641 pages. So there is the authoritative summary of 149 pages. There's also the public pronouncement of 61 pages. So you can have a look at, perhaps start with the public pronouncement, and if you get engrossed in it, then seek more information. Mr. Ayash was found guilty. Mr. Meray, Onesi, and Sabra were found not guilty. As I think you have already gathered from what I've been saying, the case was incredibly complex. The investigators examined the circumstances and the use of mobile phones in an attempt to find their users. And we're talking about hundreds of thousands of telephone calls or data on telephone calls. And then the judges had to analyze that same data and, in fact, to go through the steps themselves in order to determine whether the patterns that the prosecution alleged do, in fact, appear. The verdict was unanimous on each count. And the judges said that given the prosecution evidence is almost entirely circumstantial, the chamber had to assess each piece of evidence in the context of all related evidence, and only from reviewing the relevant facts in their entirety could they actually see whether patterns emerged. And again, as you know, the patterns that emerged had to be something that is beyond coincidence and something that convinces them beyond reasonable doubt. So the threshold obviously is very high. Regrettably, in Lebanon, the main takeaway from the judgment was that Ayash somehow acted alone, but that unfortunately is more due to the erroneous headlines than to the reality of the case, because as you will have seen from everything I've said thus far, that is completely wrong. The trial chamber found that there had been agreement between two or more people to commit a terrorist act by means of an explosive device in order to assassinate Mr. Hariri. They found that the 6 core Red mobile users must have known that they were tracking Hariri on the day of the attack, both from their actions that day and their role in the surveillance leading to it. The suicide bomber who triggered the explosive device that was on the truck must have known that he was detonating an explosive device in a public location in a manner intended to spread terror that would kill, and that it would kill and injure people. The person who made the video of the false claim of responsibility for the attack also must have known of its connection with Mr. Hariri's intended death. And the conspiracy may have included those who purchased the truck or loaded or obtained, for that matter, the explosives. And the evidence related to the historical and the political background of the case points to it being a political act directed by those whose activities Mr. Hariri's actions were threatening. Just one other note. So the forensic evidence showed that there was indeed another individual who could not be identified, of whom I think 91 or 92 pieces literally remained, totaling approximately 1 kilo or under a kilo. And it simply, there was no, the DNA evidence could be extracted, but it could not be matched to anything. What the evidence showed is that Mr. Abu Adas, who was in the video, was not a match to that DNA evidence. So the suicide bomber was somebody other than Abu Adas, and Abu Adas has never been heard from again. As I mentioned, the judges found that Ayash did not act alone, that more than 20 individuals used the 4 different networks. He was, however, the user of a phone in each of the networks. And one of the networks included the late Mr. Badruddin, who was celebrated as a senior, as the field commander of Hezbollah when during the funeral attended by Mr. Nasrallah in 2016. The judges determined that the attack was carefully planned and implemented with the false claim of responsibility as well. They also found that it did not occur in a political vacuum or a historical vacuum, and that while noting that motive is not a legal element of any of the crimes charged, they said that understanding the political background to the attack gives context to why Mr. Hariri was targeted in this matter, as it relates to whether the accused on trial are guilty of the counts. The trial chamber was also of the view that Syria and Hezbollah may have had motives to eliminate Mr. Hariri and some of his political allies. They found that the date on which the conspirators had decided to proceed with the attack coincided with 2 important events in early February 2005. One was the visit of the Syrian deputy foreign minister at the time, Mr. Walid al-Mualim, who is the current foreign minister, to Mr. Hariri's home. And it also coincided with the 3rd meeting of the anti-Syrian opposition in Beirut. These events were found to be very important in relation to the attack. However, the judges also stressed that they're not a Truth and Reconciliation Commission and could only pronounce on whether the prosecutor has proven beyond a reasonable doubt the charges against the 4 accused listed in the indictment. So that is something that is very important to keep in mind as well. And this concludes the presentation on the judgment, on the case and the judgment itself. I will just mention what other cases the tribunal has under its jurisdiction, and that is the connected cases, which is against the same Mr. Ayash, but not the other accused. And he's indicted for his participation in the attack against Marwan Hamedeh on the 1st of October 2004, which resulted in 1 death and injuries to Mr. Hamedeh and others. The attack against George Howie on the 21st of June 2005, resulting in his death and injuries to another person, and against Mr. Elias El-Mur on the 12th of July 2005, resulting in 1 death and injuries to Mr. El-Mur and more than 20 other individuals. And again, Mr. Ayash is charged with 5 counts: conspiracy aimed at committing a terrorist act. In the alternative to conspiracy aimed at committing a terrorist act, a criminal association, committing terrorist acts, intentional homicide with premeditation, attempted intentional homicide with premeditation. Yes, these are the charges against Mr. Ayash. in the connected cases. The case is currently in pretrial. There were 2 contempt cases that were held at the tribunal, one of which resulted in acquittal and the other one in a conviction, and both had to do with the alleged disclosure of confidential witness information from the tribunal. So I will conclude there, and I'm happy to take your questions or comments.
Thank you so much, Lola. That was super informative. So I have a couple of questions here in the chat, but we do have plenty of time, I think, until, we have another 40 minutes. So if you did want to show that video, if it's available, would you like to do that before we proceed? Do you have it?
No, I think we can go with the questions, and then maybe, if we have time at the end, we'll do the video.
We'll wrap it up. Okay, sounds good. So the first question is, relates to the law that's applied by the tribunal, and when you mentioned that Lebanese law is the substantive law and the procedural is international, is there any challenge in trying to apply both, both the Lebanese and the international, particularly when it comes to presentation of evidence and hearing testimony from the witnesses? That's the first question.
Not to my knowledge, for the simple fact that the mix is, so the substantive law is Lebanese law, right? But procedural law is according to the rules of procedure and evidence at the tribunal. So basically the trial unfolded in line with the rules of procedure and evidence, and people, like in every international tribunal, as you know, Hannah, everybody has to adapt to that system, right? Whatever system they come from, the lawyers simply have to adapt to the system at the international tribunals, which is a hybrid in and of itself. It's neither a common law nor a civil law system to the extent that that distinction exists, even, and some would argue that distinction is also being lost. But in any case, the proceedings at the international tribunals, and the STL is the same, are different to those in national courts, be they national courts of Lebanon or national courts of the US or the UK or other common law systems. So basically, all the lawyers in the courtroom proceeded in accordance with the rules, interviewed witnesses in accordance with the dynamics of the case, with the prosecution evidence coming first, with the defense being able to cross-examine, and so on. So in that sense, I'm not aware of any difficulties that would have been presented in the case itself. In terms of the substantive law, the tribunal benefits from the fact that it has both international and Lebanese judges, and that's precisely the reason why there are Lebanese judges, and not just judges, but also staff. So presumably as well, this did not create in and of itself problems. We did have, or at least none that would make it outside of the deliberation rooms or chambers or something like this. What we have seen is a couple of interesting appeals chamber decisions on questions of the law, because at the beginning, for example, the decision that I mentioned that was issued in 2011 was in response to a number of legal questions from the pretrial judge, who wanted some clarity from the appeals judges on the interpretation of the law before he decided on whether or not to confirm the indictment. So these were some of the ways in which some of the possible uncertainties, if you will, that at least the pretrial judge felt there were aimed to be resolved. There's another decision that came much later on the definition of conspiracy, or the clarification of the definition of conspiracy under Lebanese law. I hope that answers the question.
Yeah, and then the second question you've already touched upon, but it does relate to the composition of the benches. And so you've mentioned there's Lebanese judges, and then there's international judges. Maybe could you say a little bit more about how the judges are appointed, and maybe on the international side, sort of where they're coming from?
So there's 11 judges at the tribunal. They come from different continents, and less than half of them are Lebanese. The international judges are appointed by the UN, the Secretary General, and Lebanese judges were recommended by the Lebanese authorities. Trial chambers consist of 3 judges, 2 internationals and 1 Lebanese, plus 2 alternate judges, 1 international, 1 Lebanese, and the appeals chamber of 5 judges, 3 international and 2 Lebanese.
Great, thank you. We have another question that has to do with sentencing. So could you say a little bit about what sentence was meted out with regard to Ayash, and what's the process for sentencing? Has it already happened? And is he in custody? And here maybe you might want to talk about the in absentia procedure that's allowed at the STL, which is for us as American lawyers a little bit, interesting and different.
Yes, I should have mentioned that at the outset. So somehow it's become so associated with the STL that I almost assume that it's a known fact. But yes, so STL is unique among international criminal tribunals in that it can conduct trials in absentia, in the absence of the accused, which I know is a bit of an unusual thing for a lot of lawyers coming from the common law system. But not so for lawyers coming from the civil law system, such as the system in Lebanon, where these proceedings are just part of the system. So what happened was, once the judges made a decision to proceed in absentia because the accused could not be located, each of the accused were appointed a defense team. This is where the defense office comes in. So each of the accused was appointed with a defense team and represented by a defense team throughout the trial. So if you were to tune into any day of the trial at the STL at any given moment, and you had no clue that it was conducted in absentia, you wouldn't necessarily notice. Because the trial, in international courts, the accused, of course, are present, but they're silent, right? So in this sense, it was, again, in terms of proceedings, there was nothing really different that I'm aware of, that in terms of how the trial proceeded and how the evidence was presented and how the witnesses were questioned. There's nothing really different to a situation in which the accused was present. Clearly, the defense teams did not benefit, as far as we know, from any contact with the accused, because they would have been obliged to report such contact to the judges. So that, of course, for the defense teams would have been vastly different than a trial with the accused present, because their role was very different. But in terms of the dynamics of the actual proceedings, like I said, you wouldn't have necessarily known if you just tuned in and didn't see that there was not an accused present in the courtroom, because the prosecution was presenting evidence, the defense counsel were questioning the provenance of the evidence, they were cross-examining very vigorously the witnesses, and so on.
Great. Could you tell us a little bit about sentencing for this case?
Yes. Sorry. The sentencing hasn't happened yet. So at the STL, these proceedings are separate, right? First, the judges issue a verdict. Then the parties were invited to make submissions, which they did. And now we're waiting to see whether the judges will schedule a hearing. I understand that so they might or might not schedule a hearing, a sentencing hearing, following which they will issue a decision on sentencing.
Thank you. So I have another question here, and it's related to more recent events. So as you mentioned earlier, the trial judgment was rendered around the time of the recent explosion, right? And in fact, I think you postponed the delivery of the judgment because of the explosion and what had happened this past August. So in light of that recent explosion and calls from citizens in Lebanon, individuals in Lebanon for an international investigation, do you see any potential establishment of another international investigation or tribunal for looking into that explosion?
That's a very interesting question. I don't have an answer to that. I mean, the outcry and the demand for an international investigation is very understandable, because today, more than 2 months after the explosion, there's absolutely nothing coming out in terms of any investigation conducted by the Lebanese authorities. And nobody's hopeful that anything useful will emerge, because it's anyway, there's not much faith in the way that the investigation is being conducted and what outcome it might bring. At the same time, the reaction to the judgment in the Ayash et al. Case has been, well, it's been understandably muted because of the events, right? Because the judgment was issued on the 18th of August, and it was supposed to be issued, as you mentioned, on the 8th, but then because the explosion took place on the 4th, it was postponed by 10 days. But also because people had very, very unrealistic expectations in terms of what the judgment might provide, right? So a lot of people who were supportive of the tribunal were not necessarily understanding of the fact that of the limitations of the tribunal in terms of its jurisdiction, in terms of the fact that it only has jurisdiction over individuals and not groups, and so on. So a lot of and then of course there were the opponents of the tribunal, because the whole situation, I mean, what we're dealing with is, as the judges ruled them as well, a political act. So clearly you're going to have political divisions vis-a-vis that act. That is just a given, right? So, you know, the situation is such that many people are very disappointed by basically people are either disappointed or dismissive of the judgment for the most part. There's very few people who actually even bothered to take the time to read it, to understand it. And I find this when I speak with groups and individuals in Lebanon a lot. Once they hear even just the basics about the facts that were in fact established, you get a different reaction, invariably. But the problem is that that's just, you know, when you speak with people or a group of people, and not something that they would ever hear in the media, or they would, you know, hear from politicians or people on the ground. And the STL, just like every other international criminal tribunal, is at a disadvantage in this respect, because the voices against these institutions are always going to be louder and have more access to media than the tribunals themselves. And of course, the STL in that respect is no exception. So I don't know how that bodes for the international investigation, but people are genuinely and in great numbers demanding some kind of an international investigation or assistance in this matter.
So somewhat related to what you just said, Lola, I'd like to throw in a question, and it has to do with the judge's statement in the judgment that they're not a Truth and Reconciliation Commission. And that's not the purpose for the establishment of the Special Tribunal for Lebanon. So I'm wondering if you can talk just a bit more about what is the purpose of this tribunal? What was the intent and the reason for which it was established, its goals, if you will, in the bilateral agreement between Lebanon and the Secretary General's office? And with regard to the victims, families of victims in particular from the explosion in 2005, what is their sort of perception of the tribunal generally, and to this judgment specifically at this time?
Well, to answer the second question first, my understanding from colleagues who do interact with the victims is that they are grateful for the trial, for the tribunal, for the existence of the tribunal, for the fact that all these facts have been established, that their suffering was at least in some ways acknowledged. Of course, they're disappointed that there is, one conviction, that the tribunal couldn't establish who the organizers behind the attack were and all and that. But their feeling is predominantly is let's say considerably more positive than what you would find in the general population, let me put it that way. And again, this is anecdotal. There's no surveys that have been done or anything like this, but this is the feedback that we've been getting. In terms of what the aim was, again, it's difficult for me to say with certainty. Obviously, I can read about what was intended and everything else, but was not obviously privy to all the discussions. My understanding is that there were very lofty ideals attached to this tribunal, same as there usually are. And that is, there were so many assassinations in this country that it almost became like a way of doing politics. And it was seen as a possibility to put an end to all of that somehow, that to put an end to impunity, to stop the assassinations and so forth. And some would argue, some would disagree with that, that the assassinations, at least for the first few years, did abate. Now, again, it's so difficult, just like with any other tribunal, it is difficult, if not impossible, to determine to what extent which fact or reality on the ground played into a certain situation. So to what extent the tribunal had any impact in the early days, and to what extent something else that was going on geopolitically had an impact. So it's impossible to gauge. But initially, the idea was, to stop impunity. And as I mentioned in my presentation, friends who have lived through that period, preceding the establishment of the tribunal, preceding the request for the tribunal, really describe it as an absolute horror, because they literally say that it felt like every single week somebody else was being blown up. And so, you could see, again, we need to look at the context in which all of this occurred and what was going on, not just in Lebanon, but everywhere else at that time. We were still in the golden age of international criminal justice, if you will, which looks a lot different today in 2020 than it did, and people are a lot more cynical. So even when they look, backwards onto why somebody created a tribunal, if they look through the prism of 2020, they might have a very cynical view of what people thought and what their intentions were. But I'm not convinced that that would be a correct view, because, as I said, it's important to look at the whole context in which this occurred, that there were genuinely very high, lofty ideals behind this. And that played into the expectations, which were simply too high. But then they always are when it comes to international tribunals. I mean, we had that at the, with the ICTY. We had incredible expectations. And these institutions are just not meant to be able to meet these expectations. And not being a Truth and Reconciliation Commission is just one way of saying it. But just to finish with another point on that same note, there was a fascinating presentation by a Dutch historian at the Legacy Conference, the ICTY Legacy Conference in Sarajevo in 2017. And I believe it's available on the ICTY website, and I would warmly recommend listening to it if anybody's interested in that aspect of things. What he basically pointed out was that judges work with a very high threshold, right? So judges have to rule on the basis of beyond a reasonable doubt. If they don't receive evidence that convinces them beyond a reasonable doubt of somebody's guilt, they must acquit. It's not a question of if, it's an imperative, right? Historians, politicians, analysts, policymakers do not operate with that threshold. They simply do not. There is no other, there's no one other than judges that operates with that kind of a threshold in any walk of life. So the point he was making apropos ICTY judgments, but I think it applies across the board to any judgment of an international court, is that there are not just judgments, he was talking about cases as such. They're a treasure trove of information. They're a treasure trove of information for historians, because historians can make their conclusions on a much lower threshold. In fact, they always do, right? So even the evidence that sometimes is not admitted as such quality and value that would lead to the beyond a reasonable doubt conclusion can still be very compelling evidence in a historical narrative and can be part of a historical narrative. And this is, I think, what people need to also take into consideration. There is so much information in this case that could be useful to people in Lebanon, and not just in Lebanon, anybody interested in this country. There is, even for those who are interested purely in the political context, there is in the main judgment a whole large segment on that as well. And frankly, in a country where there's no common history book at all, even these, anything that puts together information in such a form is very useful. So it's really up to historians, up to analysts, up to others in Lebanon and outside of Lebanon to look at it from that perspective.
Great, thank you. Okay, so we have another question that goes back a bit to just the structure of the tribunal and the way it was established and set up. And it has to do with security and protection, particularly for the judges. But, what measures were taken and have been taken to ensure security with regard to the proceedings, given the subject matter, and then particularly for judges? And have there been any incidents of judges being targeted throughout the life of the tribunal? And here I just have to add as a side note that I've had judges express to me a little bit of concern about their own safety sitting on this tribunal, given that it's a tribunal to prosecute terrorism in a part of the world where the political context is very controversial. So do you want to tackle that one?
Sure. Well, the first measure that was taken, of course, was setting the tribunal up in the Netherlands, right? I mean, that was one of the reasons why it was set up in the Netherlands, and probably the main reason why it was in the Netherlands. And all the judges are based there, right? So the courtroom is there, the headquarters, as it were, is in the Netherlands, right? So what we have here on the ground is a smaller office, which is in charge of dealing with host state relations in Lebanon and requests for assistance, and dealing with, outreach, dealing with, there's an Office of the Prosecutor component as well to conduct investigations on the ground. And there is also a liaison officer for the Defense Office here for the purposes of, again, liaising with state authorities and Defense Council and so forth. So the main measure taken is to place it in the Netherlands. I'm not aware of any incident, at least none that I'm aware of have been reported in any public forum of any incident vis-a-vis judges. There was an incident back in 2010 where investigators were attacked when they were visiting a facility in Lebanon. And luckily there was nobody severely injured, but some equipment was stolen, and that is the only incident that I'm aware of. But again, if anything was confidentially dealt with, I wouldn't know about it. There is a very strong security component both in The Hague and in Lebanon. But then again, that's fairly similar to what the other tribunals have had. Particularly in The Hague, I think it's just about the same in terms of, each of these tribunals is in charge of its own security. So it has its own security section that secures the building and individuals who might need extra protection. And the same is true of the STL. The ICTY has the same. The ICC has the same. So in that sense, it's not very different. I suppose the security component here in Lebanon is somewhat different to what you might find in another field operation. But then again, I'm not 100% sure. Maybe that's the same as well. Does that answer the question?
I think it does. I don't know if you mentioned this. Do the judges have their own bodyguards? I can't remember if that's true or not.
Not individually that I'm aware of, no.
Okay.
No. They have security. Then again, all of these things are assessed and reassessed,
Right.
on a regular basis. So.
Right. Yeah. And the headquarters is in a former Dutch, like CIA type building, right? So it's pretty protected.
With a moat that surrounds it.
Exactly, a moat. All right. Another one. So this has to do, it goes back to the questions about substantive law and procedural law. Mm-hmm. And the question is whether the tribunal could indict a political party or a group. So if personal jurisdiction is only over natural persons, and why that might be the case. Was it the rules that because you would imagine that under Lebanese law, you can have more than just individual criminal responsibility, right? So is it the case that it is only individual criminal responsibility at the tribunal, and why? Who decided that is the way it should be?
It is, I presume it's because all other international criminal tribunals also know only individual criminal responsibility. So that's for the main jurisdiction that was followed as well at the STL. So no parties, no groups, no states could be indicted under STL's jurisdiction. What is interesting is that the STL has ruled that legal entities could be indicted for contempt. And in fact, they were, right? So that's something that hasn't happened to my knowledge at other international criminal tribunals, but it was done at the STL. And one of the reasons was because the judges felt that this is the direction in which the law should go. And I wonder if somebody might come up with that idea for a future international tribunal in terms of the main jurisdiction. I mean, it'll be interesting to see if there is an evolution in that direction. But to date, all international criminal tribunals only have jurisdiction over individuals. None have jurisdiction over groups.
And was that ruling on legal personality at the Lebanon Tribunal made under Lebanese law, or was that made under international law?
Well, it was judges' interpretation of the rules, but looking to Lebanese law for guidance as well.
That's fascinating. Okay, well, I have one more question if no one else does. I'm just going to check here.
Somebody has a raised hand, I can see.
Yeah. Rania?
Hi, yes, thank you. Thank you very much. Well, thanks a lot for a very informative presentation first. So thanks to the organizers and presenters. It's not a question as much as maybe a comment that I'd like to hear your comment on. It's about, you mentioned earlier that the Lebanese have been disappointed, or let's say the ones who were not dismissal of the tribunal were disappointed because they had quite unrealistic expectations of what could come out of this tribunal. And I would like to respectfully maybe disagree on that, because I think that the problem, and I'm Lebanese myself, so I'm talking from my own point of view, my own perspective, which might be biased. us Lebanese, what happens is that we're tired of the corrupt system in our country, where things get systematically pushed under a rug. And all crimes that we've witnessed over the years, most of them, if not all of them, they're almost never matched by any accountability, any responsibility. And it's true that we had high hopes for this tribunal, and unfortunately, what our perception is that it has not really offered a clear responsibility, a clear accountability for something that for us Lebanese, we consider it really the crime of the century. It's, of course, I'm talking about, this is earlier than our newer crime of the century, unfortunately, that happened on the 4th of August. And if I may add also, we are a country living through an unprecedented economic crisis. We have, I'm sure you're aware of that. I mean, we have monetary, banking, economic crisis. Everything is collapsing almost. And we are literally at the doors of maybe, I hope not, but maybe an imminent famine. And the Lebanese were hoping that, yes, I mean, they were willing to invest, because they did a huge investment in this tribunal. For us, it cost, if I'm not mistaken, correct me if I'm wrong, almost $80 billion to go through the procedure. And we were kind of hoping for something significant and clear and in return of all that. And I think this is probably where the disappointment is coming from. Of course, I'm telling you, I might have a biased opinion because I am from Lebanon, but I would really love to hear what you think about this perspective.
Thanks very much. Well, that's I think you're echoing precisely the perspective that we hear a lot of, and I have lived in Lebanon now for 10 years. And have learned a lot about this country, and most of my very, very close friends are all Lebanese, people who I interact with here. So I'm quite aware of what you're talking about in terms of being tired and fed up of what is going on. I'm quite aware of that. I'm quite understand that. I also understand the disappointment, or the disappointment in the sheer length of time that it has taken to even arrive at this judgment. I completely, understand why people would be frustrated with that fact of it having taken so long. And we can debate we can really debate whether it needed to take that long. There are probably inefficiencies in the proceedings, some of which are even addressed by the judges in the judgment. So there's certainly things that could have been done a lot better and a lot more efficiently. Absolutely. What I would say to that, and it's not a however or a but, it's and, to just take into consideration something that I think people lose sight of. This crime was committed by a highly sophisticated, highly organized group of people, highly determined group of people. It was, the intention was for that crime to never be solved. The intention was that this would be attributed to what we now know is a non-existent extremist group, of whom the person by the name of Abu Adas was meant to be representative. They even went so far as the only conclusion that anyone can draw is that Abu Adas is no longer among the living. So they went so far as to kill an individual simply to attribute the crime to him in the attempt to conceal it. They went to great lengths to conceal their very presence. I mean, these mobile phones, and again, it's very difficult to present the entirety of the findings. But for example, these mobile phone networks communicated only with each other. So we're talking about a group of people who for months on end had several telephones in their pocket or bag every single day, all day probably, but were then very carefully using each particular phone depending on the purpose for which they were using it. And the only reason why one of these networks was even recognized was because one made one mistake, right? And the investigators managed to latch onto one mistake. So one person called their girlfriend using the quote unquote work phone and not the personal phone. And it started unraveling, they unraveled the story from there. So to me, looking at this situation, I am more amazed at the fact that we know anything about how this crime was committed. And I'm not questioning how is it that we don't know everything about how this crime was committed. So this is what I would say, and what I do say to friends of mine, because I assure you, there isn't a single friend that I have in Lebanon that did not question, and was not disappointed initially by the verdict. And then when we get to the discussion of why, and they say, yes, but we all know that such and such is responsible. And I say, yeah, but we all know is meaningless in court. And we know that from all trials. The we all know is simply meaningless in court. However, as I made the point that I made earlier, it is not meaningless to historians. It is not meaningless to policymakers. It is not meaningless to analysts, so they can draw their own conclusions from the evidence that was presented, right? But again, looking at how sophisticated the people were who committed this crime, I find it miraculous that we know anything, regardless of the size of the investigation. Because don't forget, and this is another example that I think is interesting. I don't know how many of you are aware or have any idea how many FBI agents were involved in the investigation of the Oklahoma City bombing in 1995, right? Over 2,000 agents were involved in investigating that case in the initial phases. Well over 2,000 agents, right? And then, yes, they solved the case and identified the individual responsible and so forth, and that's great. But I'm saying that, it's in this particular situation, and there we were talking about one lone man with, if I remember correctly, his brother, right? And here we're talking about a super sophisticated operation that involved a lot of individuals, all of whom are intent never to be found.
Thank you, Lola. And if I could just add to that, I mean, it's not always readily apparent that for international tribunals or hybrid tribunals even, they're at the mercy of cooperation from the host state for conducting those investigations, and often are short-staffed. And the success of those cases really does often depend on the cooperation of countries, right? Because there is no police arm, if you will, for the tribunals to be able to sort of enforce and to execute their work effectively and efficiently. Maybe in closing, Lola, can you give us a sense of the future of the tribunal? And I know you had mentioned at the beginning that the tribunal's facing some budget cuts. What does the future look like, the way forward?
Well, the tribunal has one more case to conduct. As I mentioned, it's arguably a considerably smaller case, as I understand, than the main case. So that's what the tribunal is going to be focusing on going forward. It is going through a transformation of some description, but how that will play out, I cannot say at the moment, other than the tribunal remains and it's going to focus on completing its mandate. So we need to see how that's all going to look. Like I said, the case is in pre-trial at the moment. The trial is expected to begin sometime in the course of next year. I don't know exactly when. And I think just like everybody, the tribunal will have to make do with less and somehow make it work. But I'm sure they will.
Great. Well, thank you. Thank you again, Lola, for your time. I think we should let you retire for your evening and get some rest. But really do appreciate you sharing so much with us and for this really informative presentation, fascinating discussion. And to all of you, thank you for your time today and for raising such great questions and for your participation and attention. And with that, I think, Nora, is there anything else that we need to say before we wrap it up?
No, I think that's all. Thank you all for coming, and thank you so much, Ms. Cavron, for speaking. And I felt like that was so informative for me, and I hope everyone else gained a lot from your presentation. So, all right, I think that's
very much. If you have any questions, Hannah, I'm happy for you to share my Gmail.
Oh, great.
So it's really okay if people have any additional questions and stuff. And thank you very much for inviting me. And hope